I had a lot of people mention that they didn't get a chance to or weren't able to watch the actual live stream for the Duncan v. Becerra case. It is uploaded on YouTube. However, in its current state, it's about an hour and 20 minutes long. So a lot of people were saying that they just don't have the time to watch that. So what I've gone and done for the last few hours is I've skimmed through everything and I've cut out all the lesser important parts and tried to condense it as much as I could. I've got it down to about 38 minutes. So if you have about a half hour, I recommend you take the time to sit down and watch this because it'll give you a better idea of what was said without any of the extraneous information that might be repeated multiple times. I wanted to give you a better idea of just what was said without having to require you to watch a full hour and a half long video. So if you have any questions, feel free to drop it below. This is just for your information. Do not use this as a source of pure fact. I want you to do your own research and watch the whole thing if you would like to have the best possible understanding. So if you have any questions, feel free to drop a comment below, but I will also leave a link to the full-length 1-hour version if you would like to watch that. As always, thank you, and I appreciate the support.
Good morning, Your Honors. John Echeverria for the appellant defendant Javier Becerra, the Attorney General of California. The evidence in this case shows that California's reasonable 10-round limit on magazine capacity is related and furthers the government's important public safety interests in mitigating the lethality of mass shooting and gun violence against law enforcement. California's limit of 10 rounds per magazine accommodates the self-defense interests of law-abiding citizens, as this court previously determined in Factual versus Sunnyvale. The record in this case is substantially similar to the record in FIOC. It involves many of the same expert witnesses, social science data, and government studies, which this court held is precisely the kind of evidence that the state can rely on under intermediate scrutiny to show a reasonable fit. And with respect to plaintiff's takings claim, Proposition 63's ban on the possession of large capacity magazines is not a confiscatory measure.
But unlike the law in FIOC, Section 32310 lacks any exception that would allow citizens to keep, I'm going to call them LCMs, large capacity magazines, for use with lawfully owned weapons that operate without LCMs. In effect, any normal citizen with these weapons can no longer use them to protect themselves at home. This seems to be quite a severe burden on the core Second Amendment right. Why shouldn't that trigger strict scrutiny?
Well, Your Honor, there's no evidence in the record that there are any weapons in the state of California that require a large capacity magazine to operate. California has available for lawful possession magazines that hold 10 rounds or less that can be used in semi-automatic firearms for self-defense.
Those larger capacity magazines, according to the record, account for almost as half of the magazines in the United States, and they are regularly used in handguns, the Glock 17 or the Beretta, and these are the staples of self-defense. So why doesn't that impose a substantial burden if it restricts half the magazines in America, especially when they're used for guns that are typically used for self-defense?
Because there are alternatives, magazines that hold 10 or fewer rounds that are effective for self-defense.
But did the Supreme Court essentially bar that argument in Heller, where the DC said, well, yes, we ban handguns, but there are alternatives. You can have long arms. And the Supreme Court said that's no answer, just because you have alternatives, because we don't do that with any other constitutional right and say, well, you have an alternative. Why isn't that argument barred by Heller?
And the record here shows that the attributes for large capacity magazines are not for self-defense. Large capacity magazines were designed for military applications, to fire as many rounds as possible, to kill and disable as many enemies as possible in the battlefield.
There's evidence of that people at home, if you have a home invasion, that it doesn't necessarily mean that, you know, as a homeowner, that you're, number one, a great shot, and number two, that it's only going to be one person involved in the home invasion and that you're only facing one gun.
On average, about 2.2 rounds are fired. That's an average, so there may be some circumstances where more than 2 rounds need to be fired. California's law sets the maximum capacity at 10 rounds, which is far above the average.
You know, the common firearms for self-defense, a lot of them have 17, 14, 16, any number of those. When you just decide to pick 10, then next time if we say that's okay, you come back and you say, well, now we only think you need 5. And then we only think you need, I don't know how you do 2.7, but so maybe you'd round up to 3. So it sounds like a pretty slippery slope. 10 seems to be sort of a random choice.
So the weapons that Your Honor refers to can operate with magazines with 10 or fewer rounds. We are dealing here with a 10-round limit. If there is some lower limit that's imposed by a jurisdiction, then the court will have to engage in the part of the second step analysis concerning the severity of the burden to determine whether the limit is too low. So there may be some limit that is too low, and it does actually impose a severe burden on the core right of self-defense to use a firearm in defense of home.
Well, so obviously having a firearm and having 0 would be too low. You would concede that, right?
The court in Jackson seems to make clear that there is some right to magazines that are necessary to operate firearms. So if a magazine limit is set at 0, then I guess a semi-automatic firearm would only be able to fire the round that's chambered. So it'd be a 1-round shot. I think that might be too low.
How have you shown that Section 32.310 is the least restrictive means to achieve the state's compelling interest?
Sure, Your Honor. So the evidence shows that large capacity magazines enhance the lethality of semi-automatic weapons when they're used, particularly in public mass shootings. It's to more fatalities, more injuries. And the reason why California's law would satisfy strict scrutiny, even if strict scrutiny applied, and it shouldn't because of FIOC, but if strict scrutiny does apply, there is a close fit between a 10-round limit and the state's compelling interests. No one disputes that the public safety interests that have been identified by the state are actually compelling, because even legally owned large capacity magazines can be used in public mass shootings, they can be stolen and used in crime, and this can be seen in the expert report of Lucy Allen.
I want to talk about how we analyze the factual record. The trial judge seemed unimpressed with much of the factual record that the state presented. Are we just starting over again and reevaluating the factual record here without giving any credit to the trial judge's assessment of the power of the evidence that you presented?
That's correct, Your Honor. This court is reviewing the law de novo, and it doesn't owe any deference to the trial court's evidentiary determinations.
You know, that word is, FIOC keeps flying out of your mouth, and obviously that in terms of, if that is, you know, we are bound by other 3-judge panels if in fact it covers our area. Now, on the other hand, it was abuse of discretion there. Here we're de novo, and there are some factual differences in the law.
So in FIOC, the court did make binding legal determinations. FIOC court rejected the argument that a 10-round limit is a policy option that is off the table under Heller. And the court also agreed with the district court's determination that intermediate scrutiny applies. It applied because there were alternative channels that did not obliterate the ability for law-abiding citizens to protect themselves. Californians can acquire any number of magazines holding 10 or fewer rounds for self-defense. And the record indicates that those magazines can be used in a range, in most, if not all, firearms in the state of California. That large capacity magazines are not particularly suitable for self-defense. The First Circuit in Warman analogized the use of a large capacity magazine for self-defense to using a sledgehammer to crack the shell of a peanut. Even in self-defense situations, a large capacity magazine can pose a danger to others.
Well, guns pose a danger to others. You know, they kill people. What evidence in the record demonstrates LCMs that are lawfully owned by law-abiding citizens end up being used in mass shootings or other gun crimes?
I'm not aware of any evidence that contradicts the opinions of Lucy Allen. The criticisms of Lucy Allen were focused on her partial reliance on the list of public mass shootings compiled by Mother Jones.
Based on the record before us, in terms of mass shootings in California, I think they cited 17. And 14 of those 17 mass shootings, the perpetrator used multiple guns at the shooting. Given that, suppose that state of California passes a law saying there's a limit of 1 gun per household, because if someone has access to more than 1 gun, there's a chance it may be used in a mass shooting. Would that type of law, limiting 1 gun per household, pass constitutional muster.
I think that there's a possibility that that could trigger heightened scrutiny. There may be, because there would be a greater burden on the core self-defense right.
Under your reasoning, there's alternative channels. The person has a handgun or some other gun and can defend himself or herself. So under your theory, why wouldn't a law limiting one gun per household pass constitutional muster?
I don't know, Your Honor. I think that that law would be much more burdensome than the law that we're analyzing here.
Well, what if my husband and I each want a gun? You know, so then we have to share one.
Well, Your Honor, I understand that there is the possibility that other restrictions of the use of firearms in the home can impose different types of burden. Here, with a 10-round limit, where individuals can own as many 10-round magazines as they want and store them and make those magazines accessible in the home in a way that they feel comfortable with, in a way that they feel will enable them to effectively defend themselves, that does not severely burden the core Second Amendment right.
It's the magic of putting it to 10 if you could have 3 10 set up there, because under this law you could.
But the reason why why the state has decided to break up the number of rounds per magazine is that we want to require as many pauses in mass shootings as possible.
I remember reading something along those lines to say that they're taking longer in terms of shot. You know, they're not. Yeah. And so the pauses, the evidence isn't uncontroverted that the pauses really make a difference.
I see that I'm running significantly out of time.
You're okay, because we're asking you questions. You're okay, and I'll give you your full time. Why doesn't Section 32.310's complete ban of LCMs without compensation rise to the level of either a physical or regulatory taking under the Takings Clause?
Section 63's ban on the possession of large capacity magazines is not limited to grandfathered magazines. But even looking at grandfathered magazines, plaintiffs are focusing their argument on the per se physical takings theory.
On 13, but if I understand 310, if I have a large, let's say I have a SIG Sauer that has, it's 17, or so I have a SIG and this law is upheld, even though I already had that, and when I bought it, it's legal, wouldn't it become a crime?
Not necessarily, Your Honor. There is an option in Section 16740 that would allow you to modify that magazine.
Well, no, but I couldn't keep it just the way it is. If I keep that 17 round magazine, I would be I'd be committing a crime, right?
You would be deciding to keep the magazine in its original state, and that would be a violation of the penal code. So
is there an issue about the gun owner having to pay for this modification that is implicated by the Takings Clause? Because if you want to keep your weapon that has magazines in excess of 10, you have to have that magazine modified by a gunsmith, and that incurs a cost. Is that relevant to the takings issue?
That would not be relevant to the physical takings issue, unless theoretically the cost is, some astronomical number where it's impossible to modify the magazine. The California Rifle and Pistol Association represented to the Attorney General by letter that it's relatively easy to permanently modify a magazine, but it doesn't seem to be an onerous burden on owners of large capacity magazines.
Good morning, Your Honors, and may it please the Court, Aaron Murphy on behalf of the appellees. The District Court correctly concluded that California's so-called large capacity magazine ban violates both the Second Amendment and the Takings Clause. What the state has labeled large capacity magazines plainly satisfy the test that Heller articulated for determining whether something is protected by the Second Amendment, because there are tens of millions of these magazines with a capacity of more than 10 rounds owned by law-abiding citizens for lawful purposes. Because these magazines are protected by the Constitution, the state can't flatly prohibit them. Even intermediate scrutiny demands a reasonable fit, to use the words that the Supreme Court has most recently used in articulating what intermediate scrutiny demands. The state must prove that a law is narrowly tailored to serve a significant governmental interest.
So my question is, because we do have a 3-judge panel, we're bound by Ninth Circuit precedent that requires us that we apply a framework established in, we've got Jackson versus the city of San Francisco, and then we also have FIOC. And so my question is on those, how do they tie our hands? Because we're not sitting on bonk, and so how do those cases affect the standard of review that we apply?
Sure. I don't think they tie your hands here. The only one of those cases that dealt with the question of whether you can outright prohibit something that is protected by the Constitution is FIOC. And I think that FIOC, the opinion begins with a lengthy discussion of how it's an opinion that's on a preliminary injunction and that it is not resolving the ultimate question. And the opinion does, more than a dozen times use the phrase abuse of discretion as to pretty much everything it's talking about. So I don't think FIOC needs to be read as compelling the conclusion that you have to apply intermediate scrutiny here. But I will say, I ultimately don't think it makes a difference because even under intermediate scrutiny, fit matters. That's what the Supreme Court has instructed, and it's certainly not something this court can deviate from. And fit means that you have to look not just at whether the law furthers the interest the state is asserting, but whether it furthers in a manner that doesn't unnecessarily abridge more constitutionally protected activity than necessary. And if you accept the premise, as I think you have to do, that these magazines are protected by the Second Amendment, then flat out prohibiting them is just, it's the exact opposite of a fit. You don't narrowly tailor or even remotely tailor a law by saying we'll just take all the constitutionally protected conduct off the table. So I think, even if your hands were tied as to the standard of review, they're not tied as to the application of that standard of review and the ultimate determination that the law fails either way.
Do you concede that the state has a compelling interest here?
I think there's ways the state might articulate its interest that we might take issue with, but we don't dispute that, that there's a compelling interest in protecting the safety of Californians and in trying to reduce gun violence and in trying to decrease the lethality of mass shootings when they do occur. We don't dispute that those are important or compelling interests. What we take issue with here is whether the means the state has chosen are means that are appropriately tailored to serve that interest and do so without unnecessarily abridging more constitutionally protected conduct than necessary.
Do you concede that there is a level of a large capacity magazine that could be prohibited?
The right way to analyze that, I'm not kind of here to tell you what I think kind of the platonic number is. I think what you would do is whatever number is chosen by the state, you engage in the analysis that Heller articulated of asking, is this something that's typically possessed by law-abiding citizens for lawful purposes? And a record would have to be developed on whatever number is selected by the jurisdiction, but it stands to reason that there is going to be some number at which you no longer satisfy that test and you're dealing with something that's not within the scope of the test that Heller articulated for what is protected by the Second Amendment. But I think the right way to answer that question is by applying that test and asking whether something is typically possessed by law-abiding citizens for lawful purposes, rather than saying, well, yes, it's within the scope of the Second Amendment, but do you really need that many rounds or that kind of firearm? And I think it's particularly telling here that, the state has a footnote in its reply brief saying, just to make clear, we don't even think 10 is constitutionally protected. And I seem to have heard counsel today not even willing to concede that a 1-round limit would be unconstitutional. So, and I think that's really a consequence of if you don't take seriously the notion that the test should focus on typically possessed for law-abiding citizens by law-abiding citizens for lawful purposes, then you end up with no limiting principle. Every court that has applied the commonly possessed test has agreed or found it very easy to assume without deciding that whatever the limit may be, it can't be 10 because it's just absolutely clear that by sheer numbers and by the amount of magazines that are purchased. Also, as Your Honor noted, there are many firearms that come standard with magazines with a capacity of more than 10 rounds. There's some that come only with capacities of more than 10 rounds. So wherever that number is, 10 can't be the limit.
I think the evidence is lacking that there is a material number of people that go out into the marketplace independently of buying a handgun and buy large capacity magazines. I may have missed that in the record.
Yeah.
Give me a site that
Sure. Yeah. No, I think if you go to, I'm looking here for the particular expert report that we have on the statistics of ownership. I think it is from Dr. Coper's report in the record, but it's actually statistics as to magazine purchases, not firearm purchases. That well over half the magazines that have been purchased over the past couple decades have been magazines that are capable of with a capacity of more than 10 rounds, not just that the firearms that have been purchased are ones that have a capacity of more than 10 rounds. That if the test were commonly possessed by law-abiding citizens for lawful purposes, that nonetheless something that this wouldn't satisfy that test. I mean, they've instead articulated an argument that this court should apply a completely different test, and they've urged the court to embrace the test that the Fourth Circuit applied in the Colby case, where instead of asking whether something is typically possessed for law-abiding purposes, the court said, is it something that's most useful for military service? And with all due respect to the Fourth Circuit, I think that test is just flatly contradictory to what Heller says. You know, Heller makes very clear that what it juxtaposes are firearms that are commonly possessed for lawful purposes with firearms that are dangerous and unusual. And the ones that are outside the scope of the Second Amendment are ones that are both dangerous and unusual.
If intermediate scrutiny applies, what's the precise test we use? Because if you look at our court's case law on Second Amendment cases, they've applied intermediate scrutiny, but the formulation has been different.
The legal question that has to be asked, for that I would look to the guidance of the 3 times over the past decade that the Supreme Court has instructed what intermediate scrutiny requires. In McCutcheon, in McCullen, and in Packingham, the Supreme Court applied intermediate scrutiny and said the test is narrowly tailored to serve a significant governmental interest. And what narrowly tailored means is not, as counsel for the state here has said today, does it kind of get at the problem? Tailoring is about, does it get at the problem in a way that isn't overly restrictive of constitutional rights, to use the language from McCutcheon, an intermediate scrutiny case? Does the law not unnecessarily abridge constitutionally protected activity, more constitutionally protected activity than necessary? Now, a law that tries to address, say, mass shootings by looking at how do we determine who is not able to get firearms? How do we ensure that we have a more comprehensive database for determining mental health issues and appropriate ways to look for warning signs and to help people ensure that firearms aren't in the wrong hands? That's a law that is both targeted at the problem and targeted at the problem in a way that isn't designed to unnecessarily abridge the rights of law-abiding citizens to continue to possess arms that are protected by the Constitution. If this is something protected, then there's lots of things. No one disputed that the District of Columbia had a compelling interest in trying to decrease criminal use of handguns. But the one option that was off the table is just outright prohibiting law-abiding citizens as well from possessing handguns. And I do think that same reasoning is the appropriate reasoning to apply here.
Well, is it really outright prohibited? Because if you prohibited a person from having more than 10 rounds of ammunition, that would be a prohibition. In this case, all you're prohibiting is 10 rounds, over 10 rounds in a magazine, because you can have multiple magazines. There's no cap at all on how many rounds of ammunition you can have.
Sure, I think it still is a prohibition, because I think, whether you want to think of it as a magazine with a capacity of more than 10 rounds is constitutionally protected, or the other way to think about it would be, is a firearm that's capable of firing more than 10 rounds without reloading constitutionally protected? I think either way you come at that question, the answer has to be yes, because that is the kind of arms that are commonly owned by law-abiding individuals for lawful purposes. So to say, well, you can have as many 10-round magazines as you want is just to say you can't have a firearm with a firing capacity of more than 10 rounds without reloading. And if the Constitution entitles you to possess, to keep and bear a firearm with a firing capacity of more than 10 rounds without reloading, then this is an outright ban on the ability of law-abiding citizens to continue to possess that kind of firearm.
Can you address Chief Judge Lynn's question to, I think, the appellant's counsel that had to do with, all right, what do we do with the record that we have before us? What do we have to do? Do we have to look at everything and make our own conclusions anew, or is there any deference to the district court, or what's your view of that?
But, ultimately, I also think, the district court analyzed this question in many different ways and said whether I look at it through this lens, through strict scrutiny, through intermediate scrutiny, whether I look at the evidence and credit this or not, I keep coming to the same conclusion. And I think that's correct here, too, in that, even if you want to grant the state that even if you wanted to say the law furthered the state's interests, which I don't think the state met its burden of demonstrating, the state would still have this fit problem. It just doesn't have any way to say that obliterating the right to possess a magazine with more than 10 rounds, with a capacity of more than 10 rounds, is kind of a way of addressing this problem that is respectful of and doesn't unnecessarily abridge the constitutional right to possess magazines with a capacity of more than 10 rounds.
Can you address the counsel for the appellant's discussion regarding the pause issue? All lined up next to my gun. I could have it loaded and I could have 3 by that. How does that correlate with the evidence and also with, but my gun, the gun that I lawfully bought was one with a 17 round.
Right, and this is exactly where, I think the ultimate conclusion the district court reached is that what the state had demonstrated was correlation, at most correlation, but not causation, because, even if basically what the state's evidence continuously, taken in its best light, the state's evidence is saying that there is a higher level, there's greater lethality or perhaps more shots or, and then some sort of eyewitness accounts that perhaps suggest that maybe people were able to escape during pauses. And the district court looked at all of that and said, first off, I am finding, after reviewing all the evidence and the other sides, reviewing our experts and what they said about kind of selection bias in terms of what was being looked at, it wasn't clear that this was really a representative sample. And then saying, and the kind of what's being relied on to say that pauses made critical differences is really not kind of something that is reliable in and of itself. We just don't know, and we just don't have any basis to kind of draw this causal connection instead of just correlation. And I would note, this is really very much the distinction that the state's own evidence, state's own expert, Dr. Coper, back in the day, made about the 1994 federal assault weapon and magazine ban by saying, look, yes, as might happen when there's fewer things available, they are used less frequently in crime, but the relevant question, whether there was less crime or less lethality when firearms were used in crime, was exactly what he said the evidence didn't support. And in the past, in the kind of decade and a half since then, and in the 5 years since the FIOC case, this is one of the things that I think makes the record different, is that attention has been focused on that question and saying, okay, let's really drill down on this and determine whether that causal relationship has been proven. And the district court, after reviewing, an immense record here and holding an extensive hearing and hearing from both sides on everything, on all of these issues, decided that the state's evidence just didn't meet its burden. And
hypothetically, if we were to affirm the district court on the Second Amendment grounds, do we need to reach the takings argument?
You don't need to reach the takings argument. It really only matters if the court doesn't affirm the determination that the ban is unconstitutional.
It seems to me that the takings claim, the district court, district court really focused on the Second Amendment, and it seems to me that the district court conducted perhaps a rather cursory review on the analysis on the takings. So if we got to that, do you think that the issue would require a further fact-finding and record development? I have a little bit of problem with the record here.
Yeah. No, I don't think it would, because I appreciate that there are record-based questions left, but I think all of those questions are really questions about what compensation would be due, not about the legal question of whether this constitutes a taking. The takings argument is focused on that confiscatory aspect of the ban that is saying, as do people who presently lawfully possess a magazine, they have to dispossess themselves of that magazine.
And do you include within dispossession having your magazines modified?
Better way to think about that is as dispossession, because, you know, as Judge Callahan was suggesting earlier, I mean, you know, you're being told, like, I can't continue to possess my 17-round magazine. If I convert it into something else, I can possess it, but I can't possess this. And that's, to me, exactly what the Supreme Court was talking about in Horn when it rejected the federal government's argument that, oh, this isn't a taking because you could just convert your grapes into wine instead of raisins, and then you'd be able to keep them. And the court said, property rights aren't that manipulable. If you can't keep what it is that you have, then, you know, then there's a physical taking. I'll just make one final point on the takings piece. I mean, you know, the state's principal argument here is that there's no taking at all because it asserted its police power, and I just don't think that squares with the Constitution, with the doctrine in this area at all. That's exactly the argument that the Supreme Court rejected in Lucas. And while Lucas did note that the analysis might play out a little bit differently in a personal property case, all it was saying was when you apply the regulatory or physical takings principles in the personal property case, sometimes it might be harder to prove a taking. But here, where you have dispossession, there's just no support for this historical notion that if you dispossess people of their property entirely, that you can get out of paying just compensation if you call it nuisance law or something. That's exactly the argument that Lucas rejected. And it seems quite extraordinary to me to think that you could just absolutely, you know, take people's property, physical or personal or real, without paying any compensation at all. But I think it would be, you know, just particularly extraordinary if that law was somehow kind of relaxed or loosened or even easier to get out of paying just compensation, when what you're dealing with is the one form of property that the Constitution specifically singles out as something that the people have a constitutional right to keep and bear. So in a sense, you know, the takings issue just kind of reinforces the Second Amendment conclusion, and given that we are talking about something that satisfies the Heller test of being commonly owned by law-abiding citizens for lawful purposes like self-defense, the state just cannot employ the draconian option of absolutely prohibiting these types of magazines.
Mr. Echeverria, you have 3 minutes for rebuttal.
Thank you, Your Honors. I just want to address a few points. Under intermediate scrutiny, the state can rely on evidence of correlation in this case. It does not need to show causation. It can't, in some ways, show causation. We can't do scientific experiments to show that large capacity magazines cause increased fatality counts. But the evidence shows that there is a correlation, and the plaintiffs don't deny it. And Lewis clarifies.
Is there any evidence in the record to address the grandfathering issue or the lack thereof? You know, our court and other courts have said whether there is a grandfather clause for people who've held, you know, LCMs in the past as a factor to consider. And is there, so, you know, here if there are people who've owned LCMs for a decade, they're law-abiding citizens, and under the law they can no longer own it. Is there any evidence that addresses that type of situation?
Is Your Honor referring to situations where somebody has a grandfathered magazine and is using it in crime? Is that what Your Honor is concerned?
Yeah, to justify the lack of a grandfathering clause here.
Okay, well, the state of California enhanced its restrictions by banning possession, including grandfathered magazines, because it can rely on any evidence reasonably believed to be relevant under this court's precedents. And the state could look at mass shootings involving non-grandfathered large-capacity magazines to come to the conclusion that even legally possessed large-capacity magazines pose a public danger.
How does that correlate to that? Because I'm law-abiding, and I've had this 17. I have this LCM, and I've had it for 20 years or whatever, and I haven't committed any crimes. How does that correlate to that I'm going to be dangerous in my home in self-defense?
Well, the state is not singling out any individual owners of grandfathered large-capacity magazines, but what it's done is it has seen that even legally possessed firearms and magazines can be stolen, misplaced, or misused in mass shootings, or in gun crimes generally. Professor Coper notes that large-capacity magazines were used in 13 and 26% of all gun crimes. So there could be other benefits in addition to reducing the fatality counts in public mass shootings and violence against law enforcement. I'd also like to note about intermediate scrutiny, the state is not required to show that the law is narrowly tailored. That's language from strict scrutiny. Under this court's intermediate scrutiny precedents, the state need only show that the important public interests would be achieved less effectively after regulation. That is what the state is required to show. And the under-inclusiveness or over-inclusiveness of the law does not doom a statute under intermediate scrutiny. And here there is a reasonable fit, because if we only have certain use requirements on large capacity magazines, they could still be misused and could still be used to injure or kill innocent people.
Well, would you like to revise your comments about any factual findings that the district court made on the record? I mean, can we just, isn't the district court entitled, can't we rely on some of those and review them for clear error or something along those lines? Or do we just have to start over like we're the district court? That's what you seem to imply. And that doesn't seem right to me.
Yeah, I don't want to say that this court can't look at the district court and what it did. I think the district courts generally help appellate courts, even under de novo review, by examining the record. But here we're not dealing with adjudicative facts, like evidence in a criminal case. These are legislative facts. And this court is free to look at the legislative evidence that we presented here, which is nearly identical to the evidence in FIOC, nearly identical to the evidence in the 6 other federal circuit courts that did each uphold 10-round limitations in upholding the law. And the court did commit, even if a clear error standard applies, it did commit clear error by ignoring all the expert testimony, by requiring...
All right, I've allowed you extra time. Unless there are additional questions by my colleagues, I'm going to call it a day. But do either Judge Lee or Judge Lynn, do you have additional questions?
I have one more question.
Go ahead.
And California is a very large state, and there are people who live in rural areas, in the desert, in the mountains. And for them, law enforcement may be far away. They don't have a local police. They have to rely on the county sheriff. And for them, they may feel like they need a large capacity magazine to defend themselves because law enforcement may be very far away. For people who live in these areas, why isn't this law a substantial burden on their Second Amendment rights to self-defense?
So individuals have the ability to acquire any number of 10-round magazines that they need. And 10-round magazines are effective in self-defense in the home in an urban area or a rural area. And the 5 other federal circuit courts that examined statewide large capacity magazine limits, so I'm excluding the District of Columbia, they did not require some tailoring regarding specific geographic regions within the state because there was no severe burden on the core right to self-defense. So the relative need for more ammunition in certain areas of the state wouldn't fail immediate scrutiny. The burden is still not severe, and the evidence still justifies a 10-round limit.
So would your argument be different if you said that people can only, not only can they not have 17, they cannot have an LCM, but they can only have 2 10-round magazines? Would your argument because you seem to say, well, since we're going to let people have as many 10 rounds as they want, yeah, then they're not being severely impacted. But if you then go to, well, okay, we're only going to allow you 2 10s, then would that geographic argument be a better one?
It might. The burden would be incrementally more severe on the core right, but there would still be 20 rounds available for self-defense in magazines. There are also other firearms that are not even touched by California's 10-round limit that can be used in rural areas and urban areas alike. Shotguns, for example, other forms of long guns. So I'm not standing here today. I don't want to represent that strict scrutiny would apply to that kind of restriction, but the analysis might be different, and there would be a different record compiled potentially.
All right. Any additional questions from my colleagues?
No.
All right. Well, that will conclude the argument. I want to thank both counsel. You are obviously both very well prepared and very helpful to the court, and we appreciate it when lawyers know their cases and are prepared like both of you were today. Thank you very much.